Good afternoon, and thank you for joining this webinar on GP partnerships. My name is Sarah Carr, and I'm a trainee solicitor at BMA Law. I've been in the team for just over 3 years now. And for those of you who don't know about BMA Law, so we are a law firm who was set up by the BMA about 5 years ago, and we are now fully independent and regulated. For those of you who are BMA members, the benefit of using BMA Law is that you will benefit from discounted rates for using our legal services. So today's seminar is on GP partnerships, and partnership drafting is one of the core services that we offer to our client. We can assist you with a number of things related to partnerships, and this includes drafting your partnership agreement, reviewing your partnership agreement where it might be outdated, and we can recommend changes that we'd consider making. We can also provide advice to partnerships on specific issues and individual partners as well. And we can also help you deal with partnership disputes too, and that would include resolving them and advising on the best way forward. So I'll pass you over to my colleague Sana, who will introduce herself and give a brief overview of what we're looking to cover in the seminar today.
Hi everyone, thank you Sarah. So my name's Sana Sadiq. I'm a senior solicitor here in the team at BMA Law. I joined BMA Law in April of this year. But prior to that I have 5 years of experience advising clients within the healthcare sector. So during this webinar, we will take you through partnership agreements. So Sarah will look at why it is important to have a partnership agreement, when you should look at updating your partnership agreement, some recent updates to general practice that you might want to consider including in your partnership agreement. And then I will take you through things to consider including in your partnership agreement.
Thanks, Anna. So thought it'd be useful to start with a definition of what a partnership is. And this is defined in Section 1 of the Partnership Act of 1890. So a partnership is the relation which subsists between persons carrying on a business in common with a view to profit. So there's 3 key elements here. So carrying on a business, which in your case would be services, and it must be carried on by 2 or more persons, and it must be with a view to obtaining profit. So we'll look at why it's essential to have a partnership agreement. So a partnership agreement will clarify the expectations of partners. An example here would be clarifying what their sessional commitment is, whether they have any commitments to out-of-hours services. It's useful to have a partnership agreement as well for certainty, and that will set out the rights and obligations and also restrictions of partners. Having a partnership agreement will also avoid partnership disputes in some circumstances. This is essential because when things go wrong in a partnership, it's useful to refer back to a document, and it can help avoid escalating a partnership dispute, which might become costly for the partnership. So having a partnership agreement as well is useful to avoid being a partnership at will. And it's also useful to have a partnership agreement to vary the default provisions of the Partnership Act of 1890, which we'll look at in more detail now. So what is a partnership at will? So a partnership at will typically exists where there is no written partnership agreement, where the existing partnership agreement is silent on certain matters, and where there is no express or implied terms to the contrary. So an example here would be a partnership at will defines that profits are split equally between partners. Now, if the partners have decided, and by conduct, that the profits are split 60-40, then that's arguably an implied term that's to the contrary of equally split profit share. So where there is no written partnership agreement at all, and where there is no express or implied terms to the contrary, the partnership will be governed by the Partnership Act of 1890. In the Partnership Act of 1890, in section 19, provisions can be varied by unanimous consent of the partners. And although this is useful in some circumstances, it can be quite messy because you'll have numerous documents and correspondence where things have been varied. What we would recommend is that everything is contained within one document. It just makes it clearer for the partners to understand that there's one document that governs them. And it also means that it's if anything were to go wrong, then they can just refer to that one document. So we'll look at the Partnership Act of 1890 and what the default provisions of the Act say. So, as I mentioned earlier, the capital and profit losses are shared equally between the partners, which is not always the ideal situation that the partners would like. We often see partners ask that the profits are shared in accordance to their sessional commitment, which is what we would tend to include in our partnership agreement drafting. The Partnership Act also states that every partner has the right to participate in the management of the firm, which again is not always the preferred position of the partners. We often see that partnerships like to have a managing partner or a senior partner who will have certain delegated authority over the partnership. They may also have a casting vote in certain decisions of the partnership as well. The Partnership Act of 1890 also states that all decisions, except a change in nature of the partnership business, are by majority decision. Which again might not be the preferred decision. Partners may wish to have certain decisions which require unanimous agreement of the partners. This might include dissolving the partnership or admitting a new partner, and we would recommend also that altering the partnership agreement is one of those decisions that needs unanimous agreement of the partners. The Partnership Act also doesn't allow any power to expel a partner. This is particularly important, and we'd recommend that there are certain grounds included in the partnership agreement, and Sana will expand on this later on. So any partner can give notice to dissolve the partnership when you're governed by the Partnership Act. Again, this isn't an ideal situation for the partners, and it's not very stable circumstance that they might find themselves in, because any partner at any time, for any reason, can give notice to dissolve the partnership. In addition to this, death and bankruptcy also trigger the dissolution of the partnership when you're governed by the Partnership Act of 1890. What we would look to do in a partnership agreement, if we're drafting it for you, would be to carve out those provisions so that if a partner does die or becomes bankrupt, that doesn't trigger the dissolution of the partnership and the partnership can continue. So what does the Act not address? So as I've just mentioned, it doesn't address where there might be unequal capital contributions and profit shares. It doesn't address the duties of partners, which might be both clinical, administrative. It doesn't address unanimous decision making. It doesn't address leave entitlements, which would include holiday leave, maternity, paternity, adoption, study leave, compassionate leave. None of that's covered under the Act. It doesn't address a probationary period for new partners. We would recommend this is really important to include, particularly because it gives both the new partner and the partnership the chance to address whether that partner and the partnership is the right fit. And then if it's not working, then it allows either party to give a certain period of time, notice period, to leave the partnership. The Act also does not address any exit arrangements, and it doesn't address a dispute resolution mechanism. So reasons you might want to consider updating your partnership agreement include where those default provisions I've just mentioned are not suitable for your partnership, where you have a partnership agreement that's not very detailed and is silent on a number of particular matters which you want to address, where there's been changes in the partnership, and you might also want to consider updating it in line with recent updates to general practice. So if we have a look at changes in partnership, where a partner retires, it doesn't necessarily entail the need to update your partnership agreement. A well-drafted partnership agreement should be sufficient to cover all of the things that you would expect when a partner retires. However, if it doesn't, or if the terms that the partner is retiring on vary to those that are documented in the partnership agreement, we would recommend here that a deed of retirement is prepared, which documents those specific terms. An example of where the terms might vary is, say, the partnership agreement allows for a payment to the outgoing partner over 6 months. The deed of retirement might state that the payments to the outgoing partner are over 2 years. So specific terms like that we'd always recommend are documented, and specifically where they relate to payments to outgoing partners, which is quite a common area where we see disputes among partners. So where there are new partners that join the partnership, we would recommend that the partnership agreement is updated to account for this, or a deed of adherence is prepared to admit that new partner. There is some case law on this, which is the latest authority. And this case law states that even when a partner joins, it doesn't necessarily mean that it's a partnership at will if the partnership agreement's not updated. So what Chima and Jones says is that the terms will continue to apply where the partner knows they're joining a partnership governed by certain terms, i.e. the partnership agreement. And it will also apply where no one shows an intention to change the terms of partnership in light of this new partner joining. So in that case, the partner will have needed to see a copy of the partnership agreement, and they'll need to know that they are joining the partnership governed by those terms. Now, although this is the case, it can be arguable either way, and it's also very dependent on the facts. So what we would recommend for good practice is that the partnership agreement is always updated to account for new partners joining, just to avoid any uncertainty. So recent updates to general practice, which we've seen in the last year or so, include the new to partnership payment scheme. Now, if you'd like the incoming partner to benefit from the payment, which is under the scheme which was introduced earlier this year, then you might want to cover off two things in your partnership agreement. And this would include the obligation for the partnership to pay the incoming partner all the money which is received. And you'd also want to cover off how that money might be recovered should the incoming partner leave within the 5-year period. I mentioned the 5-year period because that, under the guidance, is the specified term which the partner must serve as a partner to benefit from receiving the payment. Additionally, we've also seen the clinical negligence scheme introduced, which is the state-backed indemnity scheme, and that covers clinical negligence liabilities in general practice from the date of April 2019. And recent updates as well include primary care networks. What you'd be looking after cover in the partnership agreement there would be how the money from PCN-DES is dealt with and where the income relates to the partnership. And you'd also want to be looking at covering off the relationship with the clinical director and how that fits in with the partnership as well. So I'm now going to hand over to Sana, who will talk about things to consider when drafting your partnership agreement.
Hi everyone, thanks Sarah. So now we'll look at more specifically things that you might want to consider including in your agreement. There's no obligation to include absolutely everything that I go through now with you. It all depends on what the partners agree to include. So you are free to agree the terms. So first of all, if we look at incoming partners, now Sarah already addressed a probation period. So a mutual assessment period is essentially a probation period. You might want to consider including a mutual assessment period so that you are able to have the flexibility of ending that relationship if you feel that the relationship doesn't suit the practice or doesn't benefit the practice, or the incoming partner doesn't necessarily sort of gel well with the existing partners. If you want a mutual assessment period, whilst you could agree that through other correspondence, we always recommend that it's contained within the one document. When an incoming partner joins the practice, you might also want to consider any changes to the terms in relation to profit share. So of course, the partnership agreement will set out how the partners will share in the profit share, and normally that's based on sessional commitment. In the case of an incoming partner, will they need to serve a period on reduced parity, for example? And then what happens with the excess that they're not receiving? Is that shared between the continuing partners? Is it transferred into working capital? So these are things that you really need to bottom down and agree with your existing partners before having that discussion with the incoming partner. The other thing is capital contributions. Now, capital contributions can often act as a barrier for incoming partners. If they are expected to make a large cash injection, that might not always be easy for them. So you might want to consider removing these barriers by allowing partners to pay by way of installments or by reductions in their profit share as an alternative means. Also, if the partnership owns the freehold, you also want to set out whether whether the incoming partner is required to buy into the freehold, and if they are, when will that be? Will that be immediately? Will it be after the mutual assessment period? Will it be after a number of years? So all of this needs to be agreed really, and then set out in the agreement to avoid any disputes arising in relation to what was agreed. And also we always advise that the agreement set out whose responsibility it is to notify NHS England and CQC. While this may seem obvious, if the person who is required to inform NHS England or the CQC is not aware of their obligation, then that can cause problems. So secondly, we will look at when you are taking on incoming partners, what is the difference between a salaried partner and a fixed share partner? Now, the name given to that individual partner doesn't actually determine the relationship. So you might say that a partner is a salaried partner in title, but because of the type of relationship you have, they might actually be considered self-employed, or vice versa as well. You might have a fixed share partner, but when you actually look at the details of the relationship, it might be that HMRC considers them to be employees. So it's very important that you look at the actual relationship. Now, there are various factors to look at. So first of all, will they be receiving a fixed payment? So if they are receiving a fixed payment, is that payment attached to the profitability of the partnership, or is it literally a set payment every month in the same way as an employee? Another thing to consider when you're taking on a new partner is, will they be liable for the losses and debts of the partnership? If they are not liable for the losses or debts of the partnership, and this is usually in the case of a salaried partner, will there be an indemnity to indemnify that partner for any losses and debts they do occur? And the same goes for a fixed share partner. Sometimes they will have a lower stake in the losses or debts. So that will also need to be set out in the agreement. You will need to consider in each case whether they will own a share of the partnership property and assets. And of course, if they are a salaried partner, that's unlikely to be the case. And you also need to consider to what extent they will be entitled to vote in partnership matters. So it might be that they are not entitled to vote in the larger decisions, such as dissolution of the practice, but when it comes to clinical matters and more day-to-day operations, they are entitled to vote. This is something that you can restrict in the partnership agreement and set in the partnership agreement, depending on what has been agreed. So with salaried and fixed share partners, there is some caution that you will need to consider in relation to third parties. So all partners acts have the ability to bind the partnership. The only situation where they don't have that ability to bind the partnership is where they don't have the authority to do so, and where the partnership, where that third party knows that they don't have the authority to do so, and also where that third party knows that they are not technically a partner. So this is kind of in the case of a salaried partner. So what you would want to do is here, if you have a salaried partner and you want to restrict that partner's ability to bind the firm on certain matters, you'll want to expressly set that out in an agreement. You will also want to consider with a fixed share partner how that partner's ability to bind the firm is restricted. It might be that they have lower or higher, well, more so likely to be lower authority than the full parity partners to bind the firm. So remember, when the partners, where the partnership suffers any liability, all the partners are jointly and severally liable. So in the case of a fixed share partner or a salaried partner, if they have a lower stake in liability, you will also need to consider including an indemnity. There will also this is also really relevant to equity partners. So if an individual has carried out an act that binds the firm and they had no authority to do that, it's wise to include an indemnity in the partnership agreement where that partner will indemnify the rest of the partners. So we've touched on this. So in terms of employment status, there are different rights and obligations to employees and self-employed people, partners. So employees will have a lot of statutory rights to holiday pay, national insurance contributions, leave entitlement. So it's important that you establish the relationship between this incoming partner and whether or not it's salaried or fixed share. If it's a salaried partner, they will need to sign up to an employment contract. If they are already employed, it will just most likely be a variation to their employment contract to acknowledge the fact that they are self-employed. Acknowledge the fact that they're an employee. If that partner is coming in as self-employed, as Sarah's already touched on, they will need to sign up to the partnership agreement, but there might be a variation where you want to include specific terms relating to the fixed share partner, where those terms are different to full parity partners. So there are certain events that might trigger a dispute. So we've listed some of these here. This is by no means an exhaustive list, but some examples include long-term absence or sickness absence, underperformance, misconduct, suspension or restrictions on practice by the NHS or the GMC, for instance, and deadlock. So we recommend that the partnership agreement includes terms that you can use as a reference point in these situations to either prevent a dispute or also act as a mechanism or a dispute resolution mechanism in the event of a dispute. So we will touch on absences in the next slide. Under underperformance, misconduct, suspension, etc., you may want to consider including dispute resolution mechanisms in the agreement. And the other thing is, if those dispute resolution mechanisms don't work, you might want to include provisions in the agreement that allow you to remove a partner where you haven't been able to come to a reasonable agreement. With deadlock, so ways to avoid deadlock in an agreement is to have terms relating to how partnership decisions and meetings are conducted. So there are various ways in which you can avoid deadlock. One of those is appointing a chair to chair the meeting, and then deciding on whether that chair will have a casting vote in a situation where you reach deadlock. There's also setting what will be a requisite majority. So a simple majority, as you know, is 51% of the votes going one way or the other. In order to avoid a situation like this where you're 50-50 and locked, you might want to consider setting this majority decision at a higher place. So it could be two out of three partners, or it can be 75%. That can also be set out in the agreement. So now we will look at leave entitlements more specifically. So as I've mentioned, partners, if they are self-employed, they don't have any automatic statutory rights to leave. So if you want to benefit from any leave arrangements, then these will need to be set out in the agreement. So things like maternity, paternity, adoption leave, compassionate leave, study leave, all of that will need to be in the agreement. The agreement would also need to be expressed in relation to whether any holiday entitlement is inclusive or exclusive of bank holidays. The more express you are in the agreement, the less likely there is to be a dispute in relation to any leave entitlement. To avoid disruption to the practice, you should clearly set out notice periods. So you should really restrict the ability for partners to leave at short notice, as a longer notice period will allow you to make reasonable adjustments, find locum cover or internal cover. More specifically in relation to locum and internal cover, you would want to also clearly set out who is responsible for the costs of any such cover. There are really three main options. So there's the statement of financial entitlements reimbursements, there's insurance reimbursements, and then it's just deciding who is responsible. So is it the partnership or the absent partner? There's various ways in which you can structure this. So it might be that the partnership is responsible for the cost for the first, say, 4 weeks, following which the absent partner is responsible for the locum costs, and the any reimbursements from the statement of financial entitlements or any insurance is split for the benefit of the party paying the cost at the relevant time. You should also look at profit share. Are partners entitled to profit share during any period of leave? And if they are, or if it's reduced, this should be expressed in the agreement to avoid any dispute occurring whilst that partner is on leave. And I think this is particularly important in cases such as longer periods of leave, such as sickness, maternity leave, adoption leave, and also if your partner provides for a sabbatical leave period. Is that partner entitled to profit share when they are off on a sabbatical? Where there are periods of sickness absence, you might want to consider including a set procedure to follow whilst the partner is on sick leave. So there will be requirements in the agreement such as notification requirements, so informing the practice on the first day of leave. Will the partnership agreement require the absent partner to obtain GP sick notes? Will there be a requirement on the absent partner to undergo a medical report or an occupational health report? But please bear in mind, when dealing with leave entitlements, partners are protected under the Equality Act from discrimination. So you cannot discriminate one of the partners for maternity, pregnancy, or disability. Also to add to that as well, where there is a disability, you do need to make you do need to show that you are making reasonable adjustments before any decision is made, for example, to expel that partner because they've been on leave for a long period, which we find that sickness absence does quite often lead to disputes. So ending the relationship. As Sarah has already said, if you do not have any agreement to the contrary, your only option under the Partnership Act is to dissolve the partnership when you want to end the relationship between one or more or all of the partners. So if you want to include an alternative option to end the relationship, there needs to be an express power in the partnership agreement. Now, the three most common options to end a relationship in a partnership scenario, which can be found in a partnership agreement, is retirement. So Sarah has touched on this previously, but this is when a partner has decided that they no longer want to be a part of the partnership. They have themselves served a voluntary notice to retire from the partnership, and that might be to go off and do other things, or they've reached a certain age where they've decided to retire in the professionally. The partnership agreement will then, in that case, set out the notice period requirements that will need to be achieved. Now, compulsory retirement is slightly different. So compulsory retirement arises at the end of a certain time period. So a compulsory retirement clause will allow the other partners to serve a notice on one of the partners to retire at the end of a certain time period. And this normally occurs in three scenarios that I will give you examples of. The first being where a partner has failed to return from a period of long-term leave, so sabbatical leave, maternity leave, adoption leave. The second is where a partner has been on sick leave for more than a certain period that is defined in the partnership agreement. And the final option that we normally see in a partnership agreement is where an order has been made under the Mental Capacity Act against a certain partner. In that circumstance, the other partners will have the option to ask that partner to retire. The final option that we see in partnership agreements that you might want to include in your partnership agreement is an expulsion clause. Now, there are two types of expulsion clauses. There's one, the first one is with cause, and this is the most common expulsion clause, where there will be a list of specific grounds upon which the partners can serve an expulsion notice on another partner. Sometimes there's difficulties in justifying these grounds. It's not always easy to expel a partner on a specific ground. So some partnerships might consider it sensible to include a green socks clause. So a green socks clause allows the partnership to expel a partner for no reason at all. It could be simply because you just don't like them. They're not getting along. It could be simply because they're not getting on with the other partners. There's been a breakdown in the relationship. A green socks clause is considered sensible because every party to the partnership agreement, so every partner has an equal bargaining power. So a green socks clause can be included against the background that each partner will be aware that whilst they can benefit from the clause, they can also suffer from it. So it can act as a deterrent for disruptive partners or disruptive behaviours. Now, when exercising any of these clauses, so compulsory retirement and expulsion clauses, you have to always bear in mind that each partner has a duty of good faith to the other partners. And also, you cannot discriminate against the partners for any protected characteristic. So if the partner that is subject to expulsion or compulsory retirement can show that the other partners have acted in a way that they are in breach of their duty of good faith, or they've discriminated against that partner, these will act as a means to challenge any expulsion notice or compulsory retirement notice. So we also always advise that before taking any of these steps, you take independent legal advice from a solicitor. Now, we will look at more specifically when a partner leaves the practice. So, they've either served their notice to retire, they've accepted their compulsory retirement, they've accepted that they are expelled from the partner. So this is normally once you've resolved anything arising out of those notices. You will also want the agreement to consider what happens. So will you ask the accountants to prepare specific leaving accounts, or will you wait for the next annual accounts? So there'll be cost implications. If the partnership says that you're going to prepare leaving accounts every single time a partner leaves, there will obviously be increased accountancy costs there. So the partnership agreement should also set out what that outgoing partner is going to receive in terms of payments. So will it be both the sum standing to both their capital and current accounts? If that outgoing partner is a property owner, firstly, are they required to sell the property, and will that be to the continuing partners or a new partner? Secondly, if they are required to sell the property, what will be the valuation mechanism? So that should be set in the agreement to avoid any disputes. What will their post-retirement liabilities be? So the partnership agreement should set out that they are responsible for any future, well, their ongoing income liabilities and capital gains tax liabilities, for example. What happens in relation to any claims that they might receive personally so where the partnership has received those claims. You also want to provide what partnership property and assets need to be transferred back to the partnership. There will also be an obligation to notify NHS England, the CCG, CQC and patients, and whose obligation is that? So is that the practice manager? Is it the outgoing partner's responsibility to do that? Is it the continuing partner's responsibility? You want to make that clear, just to avoid any oversight of forgetting to do that. And the final thing that you should consider including in the agreement is not compulsory, but post-retirement restrictions. So a post-retirement restriction is the ability to restrict the outgoing partner's future activities so as not to compete with the interest of the business. So there are rules around this, so it's important that you do take legal advice, because they can be challenged in court if they are unreasonable, or if they go further than is necessary to protect a legitimate business interest. So, for example, if your practice is based in the centre of London, clearly a restrictive covenant of 10 miles is not going to be reasonable, because there will be because a practice 1 mile away where there's another 3 within that mile is unlikely to be competing with the interest of your practice. One of the most common questions we get is how to mitigate against the last man standing position. So firstly, our template includes a last man standing clause. Now, a last man standing clause is where an outgoing partner leaves, instead of his share automatically transferring to continuing partners and leaving them to shoulder the risk and liabilities of the partnership without any choice. Last man standing clause gives the continuing partners the option to purchase the outgoing partner share, so they don't actually have to. Any decision to exercise this option is usually made by a unanimous decision. They will have a certain time period to decide. So they might have 3 months to decide whether to exercise the option. And if they either do not exercise that option within that specified time period, or they decide not to exercise the option at all, the partnership is then dissolved and wound up. If they do decide to exercise the option, they purchase the outgoing partner share in the normal way. Another way to mitigate against a last man standing situation is to restrict the ability to retire within a time period. So there's 2 ways to do this. The most common way is to set a minimum and a maximum notice period for partners to serve their retirement. So partners can retire 3 years in advance of their intended retirement date. They will give you 12 months notice, for example, as a maximum notice period. And that's to prevent them from getting from partners from getting their notice in ahead of others. And the other is to restrict, to provide a minimum notice period, so 6 months. So the minimum notice period should be, it's personal to the partnership, and it's whatever you consider, whatever amount of time you feel you need to plan for succession. The second option in relation to restricting a partner's ability to retire within a time period is providing a minimum gap between retirements. So it might be that only one partner can retire in any accounting period. It might be that there must be a 6-month gap between retirements. And all these things you would need to agree with your partners and then decide whether to include in the partnership agreement. It might be that you have one or all of these options in the partnership agreement. Now, another way to mitigate against being a last man standing situation is to consider the burden of paying out a outgoing partner's share and how you will alleviate that burden. So there are a number of ways to alleviate the burden of buying out an outgoing partner's share in the partnership. So the first is setting the time to pay the outgoing partner's share. So the partnership agreement might say that you can pay the partner over a period of time. That could be a number of months or a number of years. It could say whether you will be paying that partner in one go or in installments, and clearly installments will be less of a burden on the partnership. You could remove barriers of entry for new partners. And how this ties into mitigating against a last man standing situation is that if you are removing barriers for new partners, clearly when a partner retires, if it's easy for a new partner to join at that time or around that time, you're less likely to find yourself in a last man standing situation. So removing barriers would be, like we touched upon earlier, allowing the incoming partner the option to pay a one-off installment or pay on monthly installments. The other two ways to sort of mitigate the cost and burden of paying an outgoing partner is to have a operational cash retention. So that's where a certain amount is deducted each month from the partner's profit share and then held in a fund, like the working capital fund, to pay the day-to-day operational costs of the business. And the second fund that you could consider having is a sinking fund. So that a sinking fund is money set aside to deal with any liabilities in relation to the premises. So if you have these funds set aside, then it's more easier to plan for paying out an outgoing partner, because you know that these funds are protected. You know that you're going to be able to meet liabilities in relation to the premises. You know you're going to be able to meet the ongoing operational costs of the business, so you can more easily plan for how you will be paying the outgoing partner, and of course you will be taking accountancy advice during this time as well. So now we'll look at alternatives to dissolution. So you've now exhausted all avenues, and now in the partner's minds, your only option is to dissolve the practice. But is that your only option? And that's what we'll look through now. So now, one of the first options you can consider is a single-handed partner practice. So where all the partners have retired and there's one partner left, that partner can decide to take on the practice themselves, or a single-handed practice might mean that the actual existing partners might sell the practice to an outside partner or outside practice principal. Another alternative to dissolution, and I think I've said this 3 or 4 times now, is take on a new partner. It's literally one of the easiest ways to avoid dissolution or a last man standing situation. Another option would be a practice merger, and there are lots of benefits with practice mergers, including shared resources, help with administrative functions and things like that. Another option would be to incorporate, turn the transfer from a partnership to a limited company. And the benefit of a limited company is that if a member leaves or a member joins, the actual company is not affected, because the company is its own separate legal entity, completely distinct from its members, so it will continue to operate regardless of when people leave and join. Before any decision is made to incorporate a company, I would always advise that you take accountancy and tax advice to make sure that it is beneficial to you in that respect. Another option would be to transfer to a APMS contract. So this is situations where there will be a private healthcare provider taking over the practice. And the final alternative to dissolution is a sale and leaseback of the premises. So this will allow you to realise capital to pay outgoing partners and reduce the burden of sort of any payment obligations that you might have. It might be that you suddenly had another liability. It might not have anything to do with an outgoing partner's share, but a sale and leaseback of the premises will allow you to realise that capital to meet that liability. So we've now come to the end of this seminar. I've now included our contact details on the screen. I think someone asked whether we will be recording this seminar. It is recorded, and you will receive a copy of the recording and a copy of the slides. We will now open the floor up to any questions.
I think you should all have access to a chat box where you can pop the questions and we'll answer as many as possible.
You guys can expand the questions box by clicking the box with the arrow next to the question. Yeah, so you can see it a lot clearer.
We haven't had any questions in so far. Does anyone have any questions about what we've discussed in this webinar?
I can read you out a few questions if you would like.
Yeah.
What are the main issues concerning GPs in practice? Are your agreements COVID sensitive, including work for e.g. provision for remote, including, for example, provision for remote working?
Sarah, do you want me to touch on that?
Yeah, go for it.
Yeah, so our agreement does allow for, so if you want to provide for any specific terms in the agreement, such as remote working, we can provide for that in the agreement. So we can take your instructions. In terms of our actual template, so we have considered the fact that there's a changing world now with COVID-19, and we've considered the remote access more specifically in terms of decision making. So we found that a lot of partnership agreements would require you to attend the practice to attend a meeting. We've now updated these clauses to provide that remote access to partnership meetings can be achieved through telephone and video conferencing. We've also included terms such as allowing a proxy to attend on your behalf if you're shielding or too ill to attend a meeting. And we also have clauses in relation to duties, so we could look to set clauses in that more specifically in relation to duties and remote working, for example.
What would you suggest if there was a partnership agreement that has been in place for 8 years?
If a partnership agreement has been in place for 8 years, it's most likely there will be areas where, especially where there's been changes in the partnership, there'll probably be areas where the terms are not applicable to the way in which the business is operated in. There will also be a lot of updates that you might want to consider. So it's unlikely that a partnership from 8 years ago will effectively deal with primary care networks. It won't include anything to do with the new to partnership payment scheme, for example. So there will be updates to general practice that you might want to consider including in your agreement. There also might be changes to the actual constitution itself, so the actual partners, and whether you need to remove and add partners to the existing agreement. If the partnership agreement is 8 years old, you might also be coming into issues about the validity of certain clauses, or whether the actual agreement is applicable at all for reasons such as the ones that Sarah touched on. So I don't know if you want to go into more detail about that, Sarah.
I think you covered the majority there, really. Yeah, just as Sana mentioned, any changes in partnership, I just advise that you want to be really careful how they've been documented and whether you are at risk of being a partnership at will.
Can there be more than one managing partner in a surgery, and can the other partners get rid of one?
Yeah.
So yeah, I can take. Do you want me to take this one, Sana? Sorry.
Yeah.
So there can be more than one managing partner. We would take your instructions on that. Where you'd want to be careful considering there's more than one managing partner is where the managing partner might have a casting vote in partnership decision-making clauses. If that were to be the case, then you'd need to consider which managing partner has the casting vote or whether both of them have authority within the partnership. If you're asking whether you can get rid of a managing partner and how you do that, we often see in the partnership agreements, and we have this in one of our templates, that the managing partner will sit for a certain period of time as managing partner, and you might want to consider certain provisions as to how they're removed, whether that's by unanimous agreement of the partners, and then you'd want to consider how you choose who the next managing partner will be. So we would take your instructions on specific things you would want to consider there, but in terms of how you would do that currently, we would be able to provide you with advice if we could review your partnership agreement and all the documentation that would go with that.
Can BMA Law assist with Scottish partnership agreements?
So BMA Law is a firm of solicitors that is registered in England and Wales. So if you are a Scottish practice, much of what we've discussed in the agreement will still, in this webinar will still apply to you. But if you wanted to get a partnership agreement, we do have partner firms in Scotland who we can refer you to, and where you will still get preferential rates.
Can an ANP partner be a managing partner?
An ANP partner. I'm not sure I know what the
Advanced
acronym
nurse
stands for.
practitioner.
Oh, okay. Yeah. Do you wanna touch on that, Sarah?
Yeah, if they're a partner in the partnership, but there's no reason why they couldn't be a managing partner. Essentially, the provisions that we'd cover off in terms of what managing partner does, it may be that they have authority over a number of things in the partnership and a number of decision-making decisions that they come to make, but if you'd have to think carefully about whether you would want the MP to be a managing partner and whether there'd be any issues with their decision-making clauses and so things like that. But again, I don't see any reason why they couldn't be.
So it's just to add to what Sarah said as well, our template does include the ability to add non-medical partners, nurse partners, pharmacist partners. So you can, so you don't have to be a GP, an actual general practitioner, to be a partner in the partnership. We can also add provision for pharmacists, nurses, like I said, non-medical partners. We're increasingly seeing practice managers brought into partnership under a non-medical partner provision. And usually what we see is that their decision making, so they're excluded from votes in relation to any clinical matters, but any operational and non-clinical matters will consider their vote. And there are obviously changes in the way their profit share is calculated because they don't technically work sessions. So all of that is something that we can have a discussion with you about and consider including in your partnership agreement.
What is specified majority, and is there an advantage?
So a specified majority is where you set how many votes is needed for a decision to pass. So a specified majority it will be defined in the agreement, and it can be, for example, 75% of the partners, or it can be 3 out of 5 partners. For example, you can literally decide what you want to be a specific majority, and then so that will tie in with the decision-making clauses, in that the decision-making clauses will list a number of decisions that will require a specified majority. So for instance, it might say that to admit a partner, you need a specified majority or a unanimous majority, or to apply to change your sessional commitment, a specified majority of the partners will need to agree to that. And all that means is that you need to achieve whatever the specific majority is defined as in the agreement. So if it requires 3 out of 5 partners, 3 out of the 5 partners need to vote yes on that specific issue for it to pass, for that decision to pass.
Just to expand on that, we'd recommend filtering out which decisions are unanimous and which are specified or requisite majority, just because you don't want a really long list of unanimous decisions where it will give the chance for one partner to veto decisions being made. It will hold back some of the decision making and progress if all of the decisions are unanimous. So we'd recommend splitting up decisions, and we can help with that as well in guiding you which decisions we'd recommend being unanimous and which ones we'd recommend being requisite or specified majority.
Yeah.
If you already have a partnership agreement, is it better to let you look at that and ask you to write a review rather than get a new one from scratch?
So I think in terms of an existing partnership agreement, we can sometimes it might be just worth sharing a copy of your partnership agreement with us, because we can often see just from scrolling up and down it whether you would benefit from a review, or whether you would benefit from a refreshed new template. So I think the key difference is that if you have an existing partnership agreement, and it needs a review, and then that might result in quite substantial changes, the cost to do that might then exceed the cost for a new template. So we actually offer a fixed fee to draft a new template, but we tend to charge on an hourly rate to carry out amendments, and if those amendments are substantial, then they can quite quickly outweigh the benefit of a new partnership agreement.
And we've just got time for one more question. Who do we contact for more information about preparing or updating a partnership agreement?
So
you can either contact us. Oh, sorry, Sana.
No, carry on.
Our contact details are on the slide at the moment, so please do feel free to contact us by those contact details on that. Alternatively, if you want to have a look at our website and see our contact details are also on there, and you can inquire through, and that will come through to either myself, Sana, or someone else in the BMA Law team, and we'll be able to advise and assist you further with how we can help with drafting your partnership agreement or anything else you might need.
Unfortunately, that's all we have time for. We do have a list of questions that we can pass on to Sarah and Sana and your team, if you're able to answer them.
Yeah.
Thank you everyone for joining the webinar.
Thank you, everyone.
Sana.
Thank you for joining us. Bye.